All right, hi again, Attorney Steve Vonder. We're back. This is a case we've been tracking. You know, we do a lot of torrent videos on torrent defense, illegal movie downloads, but here's a case that we've been following. It's in the Eastern District of California, and it's Strike 3 Holdings once again versus John Doe, an internet subscriber with an IP address, as you can see there, okay? So what's going on in this case is you have Strike 3 doing what it usually does, seeking a motion for early discovery in the federal courts. They want to serve a subpoena on the internet service provider. The attorney, the counsel for John Doe defendant, wants to quash. You can see here, motion to quash the subpoena and on AT&T and for a modification of the order. But basically, let's go through this real quick here. I'm not going to read it all. You can stop and read it if you want. But basically, they're trying to use the Cobbler case. This is the Cobbler Nevada case, a recent case that came down at the end of last year, which basically said, you know, just alleging that an internet subscriber is the illegal infringer, that's not enough. There needs to be something more because, you know, I may subscribe to internet and it may be one of my kids that's a downloader. It could be an overnight guest. It could be that I have an unsecured Wi-Fi and my neighbor is the downloader or one of their friends. So just alleging an IP address to be the infringer is not necessarily accurate. Okay, naming the subscriber for the IP address doesn't mean that you have the infringer. So there's a lot of flaws in how they're naming defendants in these cases. And according to the Cobbler Nevada case, which is covering the Ninth Circuit, that's California, Arizona, Utah, Washington, Idaho, you know, the western states, Montana, they need to allege something more than just, hey, they're the subscriber, so they're guilty of downloading. So that's what the Cobbler Nevada case is about. This particular case involves citing the Cobbler Nevada case to try to convince a judge that the complaint as it's written is not enough. There needs to be something more than just, hey, it's the internet subscriber. So this is a really big case that we're going to be arguing. So there has been, we're arguing, it's not our case, don't mistake that, but a case we're following because it's very important in this area of the law. So we're going to see what happens, what the judge does. But what we've had so far is the motion to quash. We've had the opposition by Strike 3 Holdings, LLC, and this is the reply. So there's talking here, S3H, this is Strike 3 Holdings, has failed to allege a plausible claim against Doe because the sole allegation tying Doe to the alleged infringement is Doe's IP address. Indeed, the allegations here are nearly identical to the allegations the Ninth Circuit found were deficient in the Cobbler Nevada case. Strike 3 Holdings, like Cobbler Nevada, failed to plead facts that could support something more than Doe's status as subscriber of an IP address associated with the alleged transmission of a Strike 3 motion picture. In the Ninth Circuit, early discovery is not appropriate when the complaint would be dismissed on other grounds, and citing some cases, some case law on that, the Wakefield case and Breaking Glass Pictures, okay? The motion to quash should be granted. So again, I'm gonna just kind of scroll through the pages here. If you wanna read it, you can read it, but basically this is the argument that's being made in the case. We're gonna see how the judge rules. This is a big case, and you know, if they're having a hard time and their technology is being challenged, in fact, there's a spot lower down here, let's go down, where they're actually, there's more information about the Cobbler Nevada case, but they attack also the, let's see here, the factual differences. They're comparing and contrasting with the Cobbler Nevada case, trying to draw some parallels to that case. Apparently there was a meet and confer that didn't go so well, an email that was not returned. They cite here, the problem with suing an IP address, see arguments infra, is that there is going to be a rough 36% accuracy rate just based on Sacramento County census data. And that's basically meaning that there's, I think if you go down here, they're arguing The calculation is based on the average number of 2.76 occupants in a home and assumes only one person is the infringer. So they're making that argument. When Doe's counsel makes a representation to Strike 3 Holdings counsel that his elderly widow client did not infringe, so it appears to me that it's an elderly widow that's being accused of downloading Tushy, Vixen, or the blacked videos. And so what this counsel is saying is there should be some supporting facts to engage and see if the wrong person has been sued. They're not sure if Strike 3 Holding wants money. So there's a lot of stuff in this. So if you want to read this, go ahead and pause the video where you need to and go ahead and watch it. But this is by Edmondson IP Law. And if we come on up here, like I said, there was some talk about the technology at issue, but we'll let you go ahead and find that. So we'll keep an eye on this. There should be a decision coming out, possibly a hearing and a decision coming out on this. So this could be really big breaking news in the world of BitTorrent defense. And AttorneySteve.com, we're going to keep you here. We're going to bring you the final decision on this case and see, maybe we'll get some insight into the impact of the Cobbler Nevada case. So stay tuned. You can find out more information about our torrent defense services on AttorneySteve.com. That's AttorneySteve.com, the first name in legal services. So check that out. Hope you like our video. Make sure you subscribe to our channel. We're here in the trenches bringing you the updated information as it becomes available. So make sure to subscribe to our channel. Thanks a lot now.